Hello, everybody. You'll have to forgive me as this is my very first podcast. And what we're going to be discussing today is the nature and scope of judicial review. Specifically, Chapter 1, which is early challenges and continuing controversy in regards to judicial review, as it pertains to the United States Supreme Court in constitutional law. Quote, whoever hath an absolute authority. Before I continue, I just want to establish some things here. All this podcast is going to be is me just reading from a book. That's all this is going to be. I'm not going to provide any opinions. All I'm going to do is do a direct read, page by page, word for word, from the book you see in front of you. Constitutional Rights and Liberties. And this is all you're going to see in this podcast, as I'm going to be speaking the entire time. So, as I said, let's begin. Chapter 1, Early Challenges and Continuing Controversy, the Nature and Scope of Judicial Review. It starts off with a quote from Bishop Hoadley's sermon preached before the king, March 31st, 1717. Quote, whoever hath an absolute authority to interpret any written or spoken laws, it is he who is truly the lawgiver, to all intents and purposes, and not the person who first spoke or wrote them. What that means is, it is the courts that are the lawgivers, that are the law interpreters. So let's start off with the classic case of Marbury versus Madison. And like I said, I'm going to be reading from basically the book that I learned from. And so I'm not going to be, like I said, I'm not going to be giving any opinions. I'm going to be reading word for word what's in this book. And I'm going to let you guys make your own minds up about it. Make your own thoughts, your own opinions, because that's what America's about. It's about exploring our constitutional freedoms. And that's what this channel is about. So let's start with Marbury versus Madison, which is 1 Cranch 137 2 LED 60, 1803. Thomas Jefferson, an anti-federalist or Republican who defeated John Adams, a Federalist, in the presidential election of 1800, was to take office on March 4th, 1801. On January 20th, 1801, Adams, the defeated incumbent, nominated John Marshall, Adams' Secretary of State, as the 4th Chief Justice of the United States. Marshall assumed the office on February 4th, but continued to serve as Secretary of State until the end of the Adams administration. During February, the Federalist Congress passed the Circuit Court Act, which inter alia doubled the number of federal judges and authorized the appointment of 42 justices of the peace in the District of Columbia. Senate confirmation of Adams' midnight, quote-unquote, midnight appointees, virtually all Federalists, was completed on March 3rd. Their commissions were signed by Adams and sealed by the acting Secretary of State Marshall. But due to time pressures, several for the Justice of the Peace, including that of William Marbury, remained undelivered when Jefferson assumed the presidency the next day. Jefferson ordered his new Secretary of State, James Madison, to withhold delivery. Late in 1801, Marbury sought a writ of mandamus in the Supreme Court to compel Madison to deliver the commission. The court ordered Madison to show cause why a mandamus should not issue, and the case was set for argument in the 1802 term. While the case was pending, the new Republican Congress incensed at Adams' efforts to entrench a Federalist judiciary and at the Federalist quote-unquote Federalist court order against a Republican cabinet officer, moved to repeal the Circuit Court Act. Federalist congressmen argued that repeal would be unconstitutional as violative of Article 3's assurance of judicial tenure, quote, during good behavior, end quote, and of the Constitution's plan for separation of powers, assuring that independence of the judiciary. It, quote, was in the debate that for the first time since the initiation of the new government under the Constitution, there occurred a serious challenge of the power of the judiciary to pass upon the constitutionality of acts of Congress. Whoop, sorry. Sorry, I lost my place. Who had sustained... Oh, wait, no. Hitherto, it had been the Republicans who had sustained this power as a desirable curb on congressional aggression and encroachment on the rights of the states, and they had been loud in their complaints at the failure of the court to hold the Alien and Sedition laws unconstitutional. Now, however, in 1802, in order to counteract the Federalist argument that the repeal bill was unconstitutional and would be so held by the court, Republicans advanced the proposition that the court did not possess the power. The repeal law passed early in 1802. In order to forestall its constitutional challenge in the Supreme Court until the political power of the new administration had been strengthened, Congress also had eliminated the 1802 Supreme Court term. Thus, the court did not meet between December 1801 and February 1803, so almost 2 years that the Supreme Court did not meet. On the 24th of February, the following opinion of the court was delivered by Mr. Chief Justice Marshall. Now, what I'm going to read to you next will be the actual court opinion in Marbury versus Madison and pertain to this issue that is the judicial branch independent. Now, this is no longer an issue because it's clearly been solved. It's been 100 plus years, 200 plus years. So, let's begin with the opinion. No cause has been shown, and the present motion is for mandamus. The peculiar delicacy of this case, the novelty of some of its circumstances, and the real difficulty attending the points which occur in it require a complete exposition of the principles on which the opinion to be given by this court is founded. First, has the applicant a right to the commission he demands? He answers this question by saying, Mr. Marbury, then, since his commission was signed by the President and sealed by the Secretary of State, was appointed, and as the law creating the office gave the officer a right to hold for 5 years, independent of the executive, the appointment was not revocable, but vested in the officer's legal rights. Sorry, this is old English. This is how it was written back then, I should say, which are protected by the laws of his country. To withhold his commission, therefore, is an act deemed by this court not warranted by law, but violative of the vested legal right. Secondly, if he has a right, and the right has been violated, do the laws of his country afford him a remedy? The very essence, and he answers this by saying, the very essence of civil liberty certainly consists in the right of every individual to claim the protection of the laws whenever he receives an injury. One of the first duties of the government is to afford that protection. The government of the United States has been emphatically termed a government of laws and not of men. It will certainly cease to deserve this high appellation if the laws furnish no remedy for the violation of a vested legal right, where the heads of departments are the political or confidential agents of the executive, merely to execute the will of the president, or rather to act in cases in which the executive possesses a constitutional or legal discretion. Nothing can be more perfectly clear than their acts are only politically examinable. But where a specific duty is assigned by law, and the individual rights depend upon the performance of that duty, it seems equally clear that the individual who considers himself injured has a right to resort to the laws of his country for a remedy. It remains to be inquired whether, thirdly, he is entitled to be remedy for which he applies. This depends on, first, the nature of the writ applied for, and secondly, the power of this court. First, the nature of the writ. This writ, if awarded, would be directed to an officer of government, and its mandate to him would be, to use the words of Blackstone, quote, to do a particular thing therein specified, comma, which appertains to his office and duty, comma, and which the court has previously determined or at least supposes, comma, to be consonant to right and justice, end quote. Or in the words of Lord Mansfield, the applicant in this case has a right to execute an office of public concern and is kept out of possession of that right. These circumstances certainly concur in this case. Still, to render the mandamus a proper remedy, the officer to whom it is to be directed must be one to whom, on legal principles, such writ may be directed, and the person applying for it must be without any other specific and legal remedy. So he goes on to say, first, with respect to the officer to whom it would be directed, the intimate political relations subsisting between the President of the United States and the heads of each department necessarily renders any legal investigation of the acts of one of those high officers peculiarly irksome as well as delicate, and excites some hesitation with respect to the propriety of entering into such investigation. Impressions are often received without much reflection or examination, comma, and it is not wonderful that in such a case as this, the assertion by an individual of his legal claims in the court of justice, to which claims it is the duty of the court to attend, should at first be considered by some as an attempt to intrude into the cabinet and to intermeddle with the prerogatives of the executive. It is scarcely necessary for the court to disclaim all pretensions to such a jurisdiction. An extravagance so absurd and excessive could not have been attained for a moment. The province of the court is solely to decide on the rights of individuals, not to inquire how the executive or executive officers perform duties in which they have a discretion. Questions in their nature political, or which are, by the Constitution and laws, submitted to the executive, can never be made in this court. What he's saying there simply is that if what you're bringing to this Supreme Court is of nature of political, if it's a political question regarding their actual branch, they can't. They're hands off. It's called the political doctrine. We'll get into it more as I continue down. And just that's an important thing to remember, that the Supreme Court, when it comes to the executive has a pretty broad power, because they're our line of defense, and that's how the courts usually see it. Anyway, it's not a straight, the executive has full power no matter what, right? But there's a but right afterwards, and it says, but what is there in the exalted station of the officer, which shall bar a citizen from asserting in a court of justice his legal rights, or shall forbid a court to listen to the claim, or to issue a mandamus, directing the performance of a duty not depending on executive discretion, but on particular acts of Congress and the general principles of law. This, then, is a plain case for a mandamus, either to deliver the commission or copy of it to it from the record, and it only remains to be inquired whether it can issue from this court. Whether it can be issued from this court. The act to establish the judicial courts of the United States authorizes the Supreme Court, quote, to issue writs of mandamus, comma, in cases warranted by the principles and usages of law, comma, to any courts appointed, comma, or persons holding office, comma, under the authority of the United States, end quote. The Secretary of State, being a person holding an office under the authority of the United States, is precisely within the letter of that description, and if this court is not authorized to issue a writ of mandamus to such an officer, it must be because the law is unconstitutional, and therefore absolutely incapable of conferring the authority and assigning the duties which its words purport to confer and assign. Woohoo! In the distribution of the judicial power of the United States, it is declared that the Supreme Court shall have original jurisdiction in all cases affecting ambassadors, other public ministers, and councils, and those in which a state shall be party. In all other cases, the Supreme Court shall have purely just appellate jurisdiction. This is, of course, very important to understand as well, to understand what the Supreme Court does and doesn't do. It has been insisted at the bar that as the original grant of jurisdiction to the Supreme and inferior courts is general, and the clause assigning original jurisdiction to the Supreme Court contains no negative or restrictive words, the power remains to the legislature to assign original jurisdiction to the court in other cases than those specified in the article which has been recited, provided those cases belong to the judicial power of the United States. If it had been intended to leave it in the discretion of the legislature to apportion the judicial power between the supreme and inferior courts according to the will of that body, it would certainly have been useless to have proceeded further than to have defined the judicial power and the tribunals in which it should be vested. The subsequent part of the section is mere I'm having tongue-tiedness. Surplusage is entirely without meaning, if such is to be the construction. If Congress remains at liberty to give the court appellate jurisdiction where the Constitution has declared their jurisdiction shall be original, the original jurisdiction where the Constitution has declared it shall be appellate. The distribution of jurisdiction made in the Constitution is form without substance. Affirmative words are often in their operation negative of their objects than those affirmed, and in this case a negative or exclusive sense must be given to them, or they have no operation at all. It cannot be presumed that any clause in the Constitution is intended to be without effect, and therefore such a construction is inadmissible unless the words require it. The authority, therefore, given to the Supreme Court by the Act establishing the judicial courts of the United States to issue writs of mandamus to public officers appears not to be warranted by the Constitution, and it becomes necessary to inquire whether a jurisdiction so conferred can be exercised. So the question whether an act repugnant to the Constitution can become the law of the land is a question deeply interested to the United States, but happily not of all the intricacy proportioned to its interest. It seems only necessary to recognize certain principles, supposed to have been long and well established, to decide it. That the people have an original right to establish for their future government such principles as, in their opinion, shall most conduce to their own happiness, is the basis on which the whole American fabric has been erected. The exercise of this original right is a very great exertion, nor ought it be frequently repeated. The principles, therefore, so established are deemed fundamental, and as the authority from which they are protected is supreme, and can seldom act, they are designed to be permanent. This original and supreme will organizes the government and assigns to different departments their respective powers. It may either stop here or establish certain limits not to be transcended by those departments. The government of the United States is of the latter description. The powers of the legislature are defined and limited, and that those limits may not be mistaken. or forgotten, the Constitution is written. To what purpose are powers limited, and to what purpose is the limitation committing to the writing? If these limits may, at any time, be passed by those intended to be unrestrained. Let me reread that. The government of the United States is of the latter description. The powers of the legislature are defined and limited, and that those limits may not be mistaken or forgotten, the Constitution is written. To what purposes are powers limited, and to what purpose is the limitation committed to writing? If these limits may, at any time be passed by those intended to be restrained. The distinction between a government with limited and unlimited powers is abolished, if those limits do not confine the person on whom they are imposed. And if acts prohibited and acts allowed are of equal obligation, it is a proposition too plain to be contested that the Constitution controls any legislative act repugnant to it, or that the legislator may alter the Constitution by an ordinary act. Between these alternatives, there is no middle ground. The Constitution is either a superior paramount law, unchangeable by ordinary means, or it is on a level with ordinary legislative acts, and like other acts is alterable when the legislature shall please to alter it. If the former part of the alternative be true, then a legislative act contrary to the Constitution is not law. If the latter part be true, then written constitutions are absurd attempts on the part of the people to limit the power in its own nature, illimitable. Certainly, all of these who have framed written constitutions contemplate them as forming the fundamental and paramount law of the nation. And consequently, the theory of every such government must be that an act of the legislature repugnant to the Constitution is void. This theory is essentially attached to a written constitution, and is consequently to be considered by this court as one of the fundamental principles of our society. So does this guy. It is not therefore, there's my opinion. I said no opinions. I have to give an opinion there. I feel the same there as this judge. Repugnant to the Constitution is void. This theory is essentially attached to a written constitution, and is consequently to be considered by this court as one of the fundamental principles of our society. It is not therefore to be lost sight of in the further consideration of this subject. If an act of legislator repugnant of the Constitution is void, does it, notwithstanding its invalidity, bind the courts and oblige them to give it effect? Or in other words, though it be not law, does it constitute a rule as operative as if it was a law? This would be to overthrow in fact what was established in theory. It would seem, at first view, an absurdity too gross to be insisted on. It shall, however, receive a more attentive consideration. It is emphatically the province and duty of the judicial department to say what the law is. Those who apply the law to particular cases must of necessity expound and interpret the rule. If two laws conflict with each other, the courts must decide on the operation of each. So if a law be in opposition to the Constitution, if both the law and the Constitution apply to a particular case, so that the court must either decide that case conformably to the law, disregarding the Constitution, or conformably to the Constitution, disregarding the law. The court must determine which of these conflicting rules governs the case. This is the very essence of judicial duty. Let me repeat that. This is the very essence of judicial duty. If then the courts are to regard the Constitution and the Constitution as superior to any ordinary act of legislature, the Constitution, and not such ordinary act, must govern the case to which both apply. Those, then, who controvert the principle that the Constitution is to be considered in a court as a paramount law are reduced to the necessity of maintaining that courts must close their eyes on the Constitution and see only the law. This doctrine would subvert the very foundation of all written constitutions. It would declare that an act which, according to the principles and theory of our government, is entirely void is yet, in practice, completely obligatory. It would declare that if the legislature shall do what is expressly forbidden, such act, notwithstanding the express prohibition, is in reality effectual. It would be giving to the legislature a practical and real omnipotence, with the same breath which professes to restrict their powers within narrow limits. It is prescribing limits and declaring that those limits may be passed at pleasure. Real dangerous territory, wouldn't you think? I think that's what he's kind of getting at here, don't you think? That if we didn't have the judicial, if we didn't have our judiciary, and the Constitution wasn't paramount. Actually, no, you know what? No. Let me back that up. I think what he's saying here is that if we didn't have the Constitution and it wasn't the main land of the law of the land, which it is, the government, Congress, at the next session could pass a law that made the entire Constitution null and void. So I agree with him here. I agree that the limits may be passed at pleasure. And anyway, let's continue on with the opinion. It's a long one. I apologize. My mouth is getting quite dry, as you can imagine. It's been like almost a half an hour. The doctrine would subvert the very foundation of all written sorry, I'm starting way before where I was at. I lost my track. Sorry. That it thus reduces to nothing what we have deemed the greatest improvement on political institutions. A written constitution would of itself be sufficient in America, where written constitutions have been viewed with so much reverence, for rejecting the Constitution. But the peculiar expressions of the Constitution of the United States furnish additional arguments in favor of its rejection. The judicial power of the United States is extended to all cases arising under the Constitution. Could it be the intention of those who gave this power to say that in using it, the Constitution should not be looked into? That a case arising under the Constitution should be decided without examining the instrument under which it arises? That's too extravagant. That's too extravagant to maintain, he says. And I agree with him. That's way too that's absurd to maintain. Like, to say that you have to look at the case-by-case situation, I guess is what he's trying to say there. And you can't just put a blanket. And I agree. And I think most people would agree with that. Okay. In some cases, then, the Constitution must be looked at by the judges. And if they can open it at all, what part of it are they forbidden to read or to obey? There are many other parts of the Constitution which serve to illustrate this subject. It is declared that no tax or duty shall be laid on articles exported from any state. Now, suppose a duty on an export of cotton, of tobacco, or of flour, and a suit instituted to recover it. Ought judgment to be rendered in such a case? Ought the judges to close their eyes on the Constitution and only see the law? The Constitution declares that no bill of attainder or ex post facto law shall be passed. If, however, such a bill should be passed, and a person should be prosecuted under it, must the court condemn to death those victims whom the Constitution endeavors to preserve? No person says the Constitution, shall be convicted of treason unless on the testimony of 2 witnesses to the same overt act or on the confession in open court. Here, the language of the Constitution is addressed specifically to the courts. It prescribes directly for them a rule of evidence not to be departed from. If the legislature should change that rule and declare once one witness or a confession out of a court sufficient for conviction, must the constitutional principle yield to the legislative act? From these and many other selections that might be made, it is apparent that the framers of the Constitution contemplated that instrument as a rule for the government of courts, as well as of the legislature. Why otherwise does it direct the judges to take an oath to support it? This oath certainly applies in an especial manner to their conduct in their official character. How immoral to impose it on them, if they were to be used as the instruments, and the knowing instruments for violating what they swear to support. The oath of the office, too, imposed by the legislature, is completely demonstrative of the legislator opinion on this subject. It is in these words, quote, I do solemnly swear that I will administer justice without respect to persons, and do equally right to the poor and to the rich, that I will faithfully and impartially discharge all the duties incumbent on me as the name of the judge, according to the best of my abilities and understanding agreeably to the Constitution and the laws of this United States. Why does a judge swear to discharge his duties agreeably to the Constitution of the United States if the Constitution forms no rule for this government? If it is closed upon him and cannot be inspected by him, if such a real state of things, this is worse than solemn mockery. To prescribe or to take his oath becomes equally a crime. It is also not entirely unworthy of observation that in the declaring what shall be the supreme law of the land, the Constitution itself is first mentioned, and not the laws of the United States generally, but those only that which shall be made in pursuance of the Constitution have that rank. Thus, the particular phraseology of the Constitution of the United States confirms and strengthens the principle supposed to be essential to all written constitutions, that a law repugnant to the repugnant or anti-constitutional is void, and the courts as well as other departments are bound by that instrument. The rule must be discharged. Another quote, we are under a constitution, but the Constitution is what the judge says it is. Charles Evan Hugh. That was a speech in May 3rd, 1907. So that, my friends, is the official, that quote is the end of the opinion. And so that's only the first portion. I'm going to take a quick break. We're going to record this in sections. This was the first section of the podcast. This portion was the opinion of Marbury versus Madison. And the next section will be comments and questions. This is the stuff that I had to read when I was doing this in school. And basically what this podcast is going to be is I'm going to try to make this informational and educational for you guys, because I know this stuff, but a lot of Americans don't know their Constitution, don't know what it means to have a Constitution, why it's so important to have a Constitution. That's what I'm here for. Ask me any questions you may have, but for the time being, we're going to stop here on page 8 of the book. First chapter has 30 pages, so that's why I'm taking a break, because that's a lot of reading. Stay tuned for part 2.